CR1 is now in session.
Thank you. Please be seated. All right. We are here this morning in our case number, Civil 25-0135, Oak Creek versus Sedona et al. First, a reminder to everyone in the courtroom, please silence your phones so that we avoid any embarrassment or disruption. As I know counsel are well aware, we live stream and record these proceedings, so we appreciate if you announce yourself and your client when you stand up. You each have a maximum of 20 minutes for your argument. We do not require that you use all of that time, although it is yours to use as you choose. An appellant may reserve some time to the extent we allow with our questions. But it's up to you to keep track of that. Now, keep in mind, we've read all the briefing and we are familiar with the record in this case. We've conferenced it and discussed it this morning. So with that, please feel free to proceed.
Thank you, Your Honor, and may it please the court. John Thorpe with the Goldwater Institute, representing Oak Creek Hospitality, LLC, the appellant. Also with me is co-counsel John Riches. If possible, I'd like to reserve 3 minutes for rebuttal. The City of Sedona has prohibited Oak Creek Hospitality from leasing out any of the mobile home units on its property on a short-term basis. That prohibition violates ARS Section 9539, which protects any 1 to 4 family house or dwelling unit from municipal bans on short-term rentals and guarantees that the owners of those houses and dwelling units can rent them out on a short-term basis, that is, for less than 30 days at a time, on the same terms and subject to the same generally applicable laws as a long-term rental. Now, the city tries to fault Oak Creek for failing to identify any city code or ordinance conflicting with the short-term rental statute. But the city misunderstands preemption in general and Section 9539 in particular in making this argument. When there's a conflict between state law and municipal law, state law trumps. It doesn't matter whether the municipal law is explicitly codified as an ordinance or a regulation, or as seems to be the case here, simply the official policy of the city, which it's expressed repeatedly in writing to appellants. Now, the court can frame this either in terms of preemption or simply the declaratory and injunctive relief that appellant seeks from the court, challenging the validity of the city's prohibition on short-term rentals on Oak Creek's property. Because that prohibition in its substance is not disputed. Unless the city gets up here and says that actually the dwelling units on Oak Creek's property can be leased out as short-term rentals, to the same extent they're allowed to be used as long-term tenants, certainly we'd welcome that, but we're not holding our breath because the city has made clear time and again at every stage in this litigation that the prohibition is in place. It's that prohibition that we're challenging, and that prohibition is preempted by state statute. Now, turning to the question at the heart of this case, the issue is really what the proper frame of reference is in analyzing Section 9539's protections.
Counsel, if I could interrupt your train of thought. I just have a factual question.
Yes, sir.
Did Oak Creek actually apply? Is there an application for the license here?
Oak Creek wasn't even able to get that far because after they purchased the property, they applied for a business license from the city of Sedona, and they were informed that one of their intended uses of the property, using it for short-term rentals, was not permitted in Sedona. And so that was where they reached an impasse with the city.
So they applied for a business license and received this in response.
That's right.
Is that, and pardon my ignorance here, is that different from applying to be able to use the properties as short-term rentals?
I don't believe any application would have been necessary beyond a business license to use the properties for short-term rentals at that point. But the city made quite clear at that point and before that to the previous owners that short-term rentals were prohibited on the property.
Okay.
So there was nothing, it was apparent at that point there was nothing left to do with the city because the city had denied permission to use it as short-term rentals. Okay. If I'm mistaken as a factual matter and that there was some kind of license at the city.
Well, let me just get at, this is in your claim that the Superior Court erred by not entering summary judgment. And as I understand it, on appeal, you are asking us not to send it back, but essentially to enter that summary judgment and order the city to allow you. I'm trying to look at if there is a barrier there to directing summary judgment because of a factual dispute about whether or not Oak Creek sort of had sufficiently walked down the path toward using the property that way. Does that make sense?
I understand. So the city has not raised any kind of exhaustion argument, and to my knowledge, that Oak Creek should have done something in addition to qualify for the license. That they haven't raised any kind of disputed factual question below or on.
And the license at issue is the business license that you indicated Oak Creek did apply for.
The business license and simply the express written prohibition on using the property for short-term rentals in a letter to Oak Creek Hospitality.
Council, how do you respond to your colleague's argument that how can there be a conflict when we just pulled the language from the state statute for our ordinance?
Well, the city has whether it's a matter of enforcement or the language of the city's zoning code. Either way, there's I think an unavoidable conflict between what the city has told appellants and what the state has declared is lawful to do.
So the enforcement of identical terms creates an issue if it departs from the state statute.
Certainly that can be the case, yes, Your Honor. And here the city does have a definition.
Do you have a case for that? I mean, it makes sense to me. Don't get me wrong, but do you have a case that says that?
I don't off the top of my head, Your Honor. I'd certainly be happy to find that in brief if the court wishes. I think as just flowing from the preemption doctrine, it makes sense that the city ordinance, whether it's a city ordinance or a regulation or simply an official stated policy of the city, if the city treats it as law and enforces it as law against a party, then effectively that is the city's law, and it has to conform with state law to the extent preemption applies. So here the city has made it abundantly clear that Oak Creek cannot use its properties for short-term rentals, even though it can use them for month-to-month leases as it currently does, or for long-term rentals. And there's simply no difference in the use other than the length of the term. Now, that's precisely what the legislature was getting at when it enacted 9539. And in Section A, prohibited a city or town from, well, I'll just read the statute. It says in Section A, a city or town may not prohibit vacation rentals or short-term rentals. Section B, a city or town may not restrict the use of or regulate vacation rentals or short-term rentals based on their classification, use, or occupancy. Now, that's precisely what the city is doing here. It's restricting or regulating short-term rentals based on their use, classification, or occupancy, because it's prohibiting them from essentially based on their status as short-term rentals, based on nothing other than the length of the lease term. So the question here is quite simply, what's a vacation rental or short-term rental for purposes of the statute? Section L4A defines it in relevant part as any individually or collectively owned single-family or 1 to 4 family house or dwelling unit. Every mobile home on Oak Creek Hospitality's property is a single-family or 1 to 4 family house or dwelling unit. The city insists that Oak Creek's property isn't a 1 to 4 family house or dwelling unit because the entire property houses more than 4 families. But here the city essentially commits a category mistake by counting the number of mobile homes on the entire parcel or lot, when the statute never speaks in such terms. The statute speaks of houses and dwelling units. And each mobile home, as a matter of plain language and other statutory provisions, is a house or a dwelling unit. A house is a building for human beings to live in. A dwelling is a place to live in, residence, house, abode. And a unit is a single thing, especially as distinguished from others or as a part of a whole. Therefore, quite simply, a mobile home is a house or dwelling unit, as a matter of the plain language of the statute. Now also, where terms aren't expressly defined in a statute, other statutes that are in pari materia, dealing with the same or similar subjects are helpful. And here, those statutes reinforce the plain meaning of the statute, that a mobile home is a house or dwelling unit within 9539's protections. We've cited a number of these statutes in our briefing, but just to highlight a couple, ARS 41-1491 in the mobile home provisions defines dwelling as a building structure or part of a building or structure that is occupied as or designed or intended for occupancy as a residence by 1 or more families. 33-1310 again defines a dwelling unit expressly as including mobile homes. 33-1454A says that a tenant shall occupy the tenant's mobile home only as a dwelling unit. So time and again, throughout the Arizona Revised Statutes, the legislature has treated mobile homes as dwelling units or as houses. And there's no reason to think that it meant to depart from that standard and ordinary usage in 9539. Similarly, the statute 9539 does not deal in terms of uses or parcels or lots in a way that Appellee's argument requires. So Appellee's argument, again, seems to count the entire property or the entire parcel or parcels and looks at the number of houses or dwelling units there and says, well, there are 59 mobile home spaces on this property. That's more than a 1 to 4 family house or dwelling unit. Therefore, the entire property is excluded. But that doesn't accord with 9539, which speaks in terms of units, not in terms of parcels or lots. And here, again, it's helpful to look at other statutes because the legislature many times elsewhere has spoken in terms of parcels or lots or properties. It knew how to do that. It could have easily done that here, and it chose not to. Again, we've cited many of these statutes in our brief, but I think what's especially important here is that in other very closely related provisions, it's spoken in terms of lots or parcels. For example, 9-462-13H2, which defines duplex. 9-461-18 governs accessory dwelling units. And there again, it speaks of dwellings on the same lot or parcel. So this certainly would have been on the legislature's mind when it was crafting the language of the short-term rental protections. It understood the idea of there being multiple housing units on a single parcel of land, and it chose simply not to speak in those terms here. The bottom line is that if a house or dwelling unit can be used for long-term rentals, the city can't prohibit it from being used for short-term rentals too. The city relies on stagecoach trails to argue that the mobile home park is a single use and therefore has to be treated, the mobile homes in that park have to be treated collectively. But stagecoach trails is completely inapposite. For one thing, it predates the statute at issue here. For another, it deals with whether a mobile home park is a single parcel of land being put to a single unified use for purposes of local zoning rules. But this isn't a case about local zoning rules. It's not a case about parcels, uses, or zoning provisions. It's a case about a state law, 9539, and whether that state law prohibits the city's ban on short-term rentals. Now, the city is certainly free to make and enforce zoning designations in accordance with its law and with state law, but that's not the issue here. It's not a question of zoning designation, because the appellant's use of the property, it's the same use as a matter of zoning, whether it's leasing out a unit for 29 days or for 30 days at a time. The question is it's not a question of zoning use. It's a question of the length of these leases, which is something the legislature has explicitly and clearly spoken on. On a related note, the city makes much of the fact that the property is, quote, zoned for single-family residential use, and the use as a mobile home park is a legal non-conforming use. From this, the city argues that any change in the parcel's current use would cause them to lose their legal non-conforming use status. But at this point about non-conforming use is a red herring. Oak Creek Mobile Lodge and its residents have the right to lease out their dwelling units. Under 9539, they have the right to lease out those dwelling units on a short-term basis on the same terms and with the same legal treatment as if they were leasing them out month to month or on a yearly lease. Again, the only difference here between the leases the city's allowing and the leases it prohibits is the length. If it's 29 days, it's prohibited. If it's 30 days, it's allowed as a month-to-month lease.
Council, I'm sorry, I'm going to draw you back to the factual question because I now have something in front of me. In your statement of facts in support of the motion for summary judgment, at paragraph 8, you say plaintiff has applied for and received a business license from the city. And then at paragraph 15, you say the city's denial of plaintiff's request for a short-term rental license was a final decision, and you go on from there. And so I guess I'm looking, and that may be something in between now and your rebuttal that you could clarify factually for me, because I know that in response, the city's controverting statement of facts disputed the assertion and says there's no allegation that plaintiff properly applied for a short-term rental permit as provided in the city code cited there. So I guess I would just like some clarity. What do we have in the record in terms of what did Oak Creek apply for and get rejected on versus what Oak Creek may not have yet applied for in this space?
Certainly, Your Honor. I'm sorry if I got muddled on the factual point about what kind of license they applied for. I think it's immaterial on appeal because the sole basis for the city's denial of Oak Creek is that
It's not immaterial to us with regard to whether or not this court has the ability to impose the summary judgment that you have requested that we impose. If there is a factual dispute, we are not in a position to direct the city on this point, and we would need to remand for clarification of that factual dispute.
Certainly, Your Honor. I think I'd await the city's council indicating if there is any kind of factual dispute. I think to date, they haven't identified any material factual dispute, certainly not in their briefing on appeal. But I think a lot of that would depend on what the city identifies as a dispute. If there are no remaining questions, I'll reserve the remainder of my time.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. I am Kristen Mackin. I'm representing the city appellees, and I have with me Monique Cody, who is an assistant city attorney for the city of Sedona. Thank you. So can you hear me okay? Okay. Just want to address as a overarching theme, and it's probably clear from the briefs, but the city has not prohibited mobile homes from being used for short-term rentals. The city has over 60 mobile homes in the city being used as short-term rental amongst its 1,200-ish short-term rentals. So there's no prohibition on mobile homes themselves being used for short-term rentals. The issue here is the definition of what constitutes a short-term rental and the dispute between the parties over that definition. And the city's definition is, save for a comma.
Could I just have you clarify that point? I think Mr. Thorpe invited you to reach agreement in front of us today on this point. You seem to be suggesting you're okay with Oak Creek using their mobile homes as short-term rentals because the city does not prohibit the use of mobile homes as short-term rentals. No. So
I'm sorry. No.
Okay.
No, I did not. I meant if they're on a separate parcel. The problem is with the mobile home park. It's a mobile home in a mobile home park, and I apologize. I should have been more clear on that. The city interprets the definition to address types of uses on the property as a whole, a single family.
What is your best statutory? So Oak Creek has provided a number of statutory provisions, both this one and then others that we would read in pari materia, to suggest that the parcel or the land is not the focus, it's the use. The house or dwelling unit is the residential use. What is the statutory language, either in this statute or other statutes, that direct us to look at the parcel or land?
Yeah. Well, and when I say parcel and use, I'm talking about the property. In Oak Creek's case, it's actually two parcels, but one single mobile home park is over two parcels. And in my briefing, I've pointed out the fact that there are other uses of the word property to refer to the short-term rentals as if they are referring to the regulation of the property as a whole. It's not relevant. It's not addressing the number, like it's an implied limitation on the number of homes or dwelling units on a property. So you can't have 59 short-term rentals in a mobile home park on one property. That doesn't satisfy the definition. It is supposed to be.
I'm sorry, the definition of which term?
Short-term rental.
Okay, and where is that? What is the definition?
The single family or 1 to 4 family house or dwelling unit. It's not just any
So house or dwelling unit, how does that get us beyond the mobile home, which you have indicated the city is okay with a mobile home being used as a short-term rental? And
when it's on its own.
seems to me that it's a house or dwelling unit. So what within that definition requires us to look beyond this is a house or dwelling unit to the nature of the land or the size of the land?
Well, it's qualified. The house or dwelling unit is not any house or dwelling unit. It's a single family or 1 to 4 family house or dwelling unit. That is implicitly, that is one use of land. You don't have multiple single family homes on one property. You have a single family home or a duplex or a townhome, but you won't have multiple of those. And when you do, then it doesn't fall within that definition anymore. Otherwise, why have the rest of the words in the sentence? Why, if it's any house or dwelling unit, regardless of number, then you get into the,
But the
apartment
number
complex.
that you're talking about requires us to look beyond the dwelling unit, the entity, the thing. These mobile homes are themselves a single or up to 4 family, right?
But you have 59 in one mobile home park. So
Sure, but why do we look beyond that dwelling unit to the ones around it to determine that there's too many?
because of the words in the sentence, that is the city's interpretation, believes that the including and limiting house or dwelling unit by single family or 1 to 4 family is a limitation on the number allowed on the parcel. And when you look at it,
Why does it get us to the parcel, I guess is what I'm trying to get at. Why do we look at the parcel? We can see that each mobile home is a single or 1 to 4 family dwelling unit. So I'm applying that language.
Right.
But what in that language, or is there another statutory provision that would help us out here to say it's only single or 1 to 4 family units as determined by the number of them on a parcel, or where do I go to see that authority?
Well, I look to the other sections in the statute if we're unclear from the definition, but in the notice provision, for instance, it refers to notice being to other residential, like adjacent residential properties. And so if you're looking at just units, then you would have to not notify all of the adjacent unit residents or occupants, and you would notify the adjacent properties. And in Oak Creek's reply brief, their response was, oh, but the word properties there doesn't really mean properties. Of course, they just mean house or dwelling unit, so you just disregard that word. And the same word appears in the violations provision. It's violations per property. It says the short-term rental property, when it has a violation, will get a notice. And when you have a very serious violation or 3 violations on the property, then one of the penalties could be discontinuing the ability to use the short-term rental, the property for short-term rental for an entire year. So under the Oak Creek's interpretation, you would have any 3 dwelling units on there, they get 1 violation and you can't use any on the property, or we again just disregard the word property there and substitute in house or dwelling unit. So to me, that is not a plain meaning of the statute. The city's interpretation, I know that it doesn't say parcel, but when you're in the land use and zoning context, you have a single family house or 1 to 4 family dwelling unit is a use of property. That's why when you're interpreting statutory interpretation, you're doing statutory interpretation that you all do all the time, and the Arizona Supreme Court has actually lots of very recent decisions going over plain meaning interpretation. All of those words have to be read in context. So maybe in the building code, a house constitutes a dwelling unit, a mobile home constitutes a dwelling unit, a unit in a condo, a unit in a apartment complex will all be a dwelling unit. But when you look at the words in context, that doesn't make sense. If we have any dwelling unit, no matter where it is and no matter the number on one property, then you're turning into really a commercial use. And we're looking at the legal non-conforming use of the park as a whole. And if you start renting out all of the individual units, regardless of the parcel, then you're really undercutting all the other prescriptions in the statute that say, well, we're going to have units in a condo or cooperative. And it doesn't say apartment, and it doesn't say timeshare. It used to say timeshare, but in 2022, the legislature deleted the word timeshare. That has to mean something. That shows an understanding that the legislature had included that type of use and has now excluded that type of use. So if the legislature wants to include mobile homes or dwelling units in a mobile home park, it's very easy to add that, but they haven't. This whole short-term rental statute is primarily allows this like kind of an exception. It takes the town's or the city's ability to regulate the use. The legislature determined that was the of statewide importance to allow individual homeowners to be able to use their property for that purpose, and then it has some tax implications with that. But if you look at every dwelling unit in an apartment and allow those to be used, for instance, for a short-term rental, then what's the difference between that and a hotel or a motel or an extended stay? And that really is a commercial use. And so then you're allowing that to come in under the guise of the short-term rental statute. And based on the language in the statute, the corresponding tax implications, I don't think that was the intent of the legislature. I don't think that's what the plain language, and I think the city's interpretation gives the best meaning and harmonizes as much as possible all of the short-term rental language there.
So your argument is also an apartment complex. I just want to let's talk about how far this rule that you're talking about would go. So anybody in an apartment complex could be prohibited from renting on Airbnb.
Yes, if it's not a condo, right? If it's truly an apartment complex, their individual unit wouldn't be able to be rented as a short-term rental.
And you're saying, so like some hotels, like they have condos and they rent them out. You're saying that's different because it's a commercial purpose?
Well, if it's a condo, then a unit or a group of units in a condominium is included as a short-term rental. So
even if it's just it's all on the hotel property?
Yes, I think if it's truly platted separately with a different parcel, like as a condo, like they would each has a separate tax parcel number, then those individual owners could, short-term rental. It doesn't matter about the use of the property there.
Have you denied an apartment holder seeking short-term rental license?
I'm actually not sure on that point. I do know I don't know. I don't know on that point, but can I talk about the communication that the city attorney had with the prior owners? It was the prior owners of the mobile home park.
Is this in the record?
Yes.
Okay.
If from the letter, it's to the prior owner. It's the same lawyers, but it's the prior owners. In anticipation, I think it was in anticipation of sale, they had that conversation. They did obtain Oak Creek, when they purchased, they did obtain a business license, but based on the communication between the city attorney and the prior lawyers on the behalf of the prior owner, they did not apply for the short-term rental permit. So there has been no application for the short-term rental.
Did you, you're the first city to raise this interpretation, right?
Yes.
And no other cities have filed amici here in support of you.
Yep.
Can we see, is there glean any meaning in that, or maybe they just don't know about it, or?
Well, I didn't personally go solicit amici,
Okay,
so
they
I don't know.
It didn't go to the League of Cities okay.
No. But I do think I do think it's an issue of statewide importance, because it would, disregarding the city thinks is an implicit limitation on the number of short-term rentals that can be on a property, would further expand the short-term rentals, which I think is also contrary to what the legislature has been doing since it was adopted in 2016. In 2019, they added, we need to add some authority for the cities and towns to be able to regulate. And then in 2022, they made some more substantial revisions to allow more power for the cities, not to prohibit, but to regulate, and add in the violations provision. That's what came in 2022. Also, when they took out the timeshare. So I think that is telling that that it's not intended to be every single dwelling unit, regardless of the number on the property. I think it's.
So is it fair to say that your argument is effectively zoning is the critical point?
Yes, looking at the zone, because you could be in a.
Zoning is dispositive, is what you're saying.
Of the parcel. That's being asked for the.
Right.
Yes.
Right.
Mm-hmm. Yes.
And even if it's
preempted
under the plain language, the zoning gets you in a different place. Is that right?
Well, I think looking at the property as a whole. But in your example, when you have a commercial zoning, if you had a hotel, commercial zoning, and also condos, then the units would be. It's the units on the condo units on the permitted there, if it's the permitted use. So I guess.
Have you read the City of Scottsdale case? It's 237 Ares 467. It talks about zoning, and it looks like it's a similar argument to what you're raising, and the court said that preemption analysis would still apply if you have a conflict, and whether it's zoning or not. I guess if you haven't read it,
I am not familiar with that.
You don't have any cases that say that's a better question, that adopt and describe your argument.
No. There's very few cases interpreting this particular statute, so it is all matter of.
Generally, zoning and preemption.
Correct. But I think that there is no conflict because we don't actually, the city's being consistent with the definition, and that's why I think we don't have that conflict. But.
Did you want to speak about the questions Judge Perkins had about whether they applying for the business license and that denial was in part because you were saying they couldn't put the property to use as they wanted to, so you denied it, or did Oak Creek apply for short-term rental license, or can you explain the city's perspective on that?
Yeah, I believe they did apply for and receive a business license because they were still running a business of the mobile home park and renting those out. So the business license is appropriate. Oak Creek did not apply. It's my understanding Oak Creek did not apply for the short-term rental permit, which would be the next step based on the representations in the city attorney's letter to the prior owner. And so Oak Creek themselves didn't actually do the application for that. But the city would interpret, the city's interpretation of the definition would apply if Oak Creek were to come forward and apply. They would, it depends on, I guess, what else is in the permit application. If they didn't meet some other criteria, that, I don't know.
Thank you.
So I guess I just wanted to emphasize again that I think it's important to remember that the plain language and interpretation is critical to look at the words in context. And in context reading the words in context is a primary interpretation method. It's not a secondary. So looking at the surrounding words in the sentence of the definition, and as well as the rest of the statute itself, including, for instance, you have specifically addresses if you have a single family residence and an accessory dwelling unit on one property, one owner has to live in one or the other. You can't short-term rental both. I think that's an indication of, and that was, I think, also a 2022 revision. I think that's also an indication that there's not an intention to have multiple single-family homes or multiple dwelling units on the property that aren't a single-family or 1 to 4 family dwelling unit on the property.
So I know you only have a minute 30 left. Can you address Judge Perkins' argument about the Imperi?
Yeah, I'm sorry, I don't have other, other statutes. I mean, other statutes show that we use the words mobile home park, condominium, apartment, all, we know how, like the legislature knows how to use those individually, and I put that I put that in the answering brief, but I don't have another more on point set of statutes to refer you to. And so if that's all, then I'll.
Thank you.
Okay, I'd like to start with the issue of relief on remand. So Oak Creek Hospitality sought a declaration that the prohibition is unlawful and cannot be enforced against Oak Creek Hospitality. This court, there's no obstacle to this court granting that relief if this court agrees with Oak Creek's argument that the state law prohibits the city of Sedona from banning short-term rentals on the same terms and on the same grounds as long-term leases. And the city has been abundantly clear at every step of the way that short-term rentals are prohibited here. Now, it's correct that, I'm sorry I muddled this earlier, but Oak Creek Hospitality applied for and received a business license. However, the city made clear that the door was shut for Oak Creek to use its properties as short-term rentals. In the letter that's been referenced, I believe this CR1 at 11, the city said mobile home parks are ineligible to be used as short-term rentals. It goes on to explain its reasoning. And then it closed this letter by saying, I trust you will not waste public resources further on this matter or your client's time pursuing any remedies available under Arizona law. Quite simply, the city shut the door to any further recourse apart from suing for a declaration and for an order allowing Oak Creek to use its properties in accordance with Arizona law.
Counsel, thank you. I appreciate that clarification. Short time left, so I just wanted to direct you to your opposing counsel's comments about in particular about the 2022 statutory revisions, the addition of the violations being per property. How do we read that particular provision in pari materia here? Does the legislature's use of the term property there, per property, relying on violations per property, direct a different interpretation, and if not, why not?
Yes, Your Honor. I think in the context of the statute here, the term property refers to a house or a dwelling unit, or the other options for short-term rentals listed in that definitional section, a condominium, a cooperative. So I think those are the properties. Those are the units of analysis everywhere else in the statute. So I think in the couple of places where the statute refers to properties, I believe also in the notice provision elsewhere in the statute, it mentions property. A property is a house or a dwelling unit. I think that's also made clear by the exceptionally broad language in L4A. The legislature phrased this in a way that makes clear it's intending to catch a lot.
What about, counsel, just in the time you have left, your colleague's argument that the timeshare language was taken out, and how do we read that?
I don't think the timeshare language really has any bearing here. A timeshare is in many ways is a fundamentally different kind of arrangement, where there are multiple owners or lessees to the property on a long-term kind of basis. A short-term rental is a whole different thing, where there's one owner, one party that has possession of the property, and it's leasing it out to different parties that don't have any kind of long-term arrangement like in a timeshare. I think there's been a rise of short-term rentals in recent years, and the legislature here was dealing with the relatively new issue of short-term rentals and regulation of those. I think it's important to note that the legislature starts with a broad kind of catch-all definition of short-term rental. regardless of ownership structure, it's any individually or collectively owned. It's single family or 1 to 4 family. And then house, and then just in case there's any doubt, it's not just a house, it's a dwelling unit too. So in that initial kind of general definition of a short-term rental, the legislature made clear its intent to make this broad. And then it goes on again, in case there's any room for doubt, that it also applies to units of a condominium. It also applies to cooperatives. Now, there's a question, I think, about apartments that this court doesn't need to resolve here. Apartments, motels, hotels are all distinct from a mobile home park because they're, for one thing, this is important, that the ownership is indivisible with units like that. You can't sell off parts of an apartment building, at least not easily, the way that you could sell off mobile home units. There are 59 lots here that could be potentially up to 59 different owners of each mobile home. And the city's interpretation bans not only Oak Creek Hospitality from leasing out any of its units on a short-term basis, but if there are one owner in the mobile home park, as soon as that mobile home is towed onto the premises, suddenly they lose their right to use their home, their dwelling unit.
Thank
on
you,
that basis.
counsel.
Thank you.
We appreciate both arguments. We will take the matter under advisement and issue our decision in due course. With that, we will stand in recess and reset for the next argument.